Judge Evelyn Monroe's shoulder hit the marble wall before she understood what was happening. Her glasses skidded across the polished floor. The sealed gray file stayed pinned against her ribs, held there by reflex more than intention, because some part of her had already decided that whatever else happened in the next 10 seconds, this file was not going to hit the ground. "You don't get to carry sealed material through this corridor," the officer said, wrenching her wrist behind her back. "My name is Evelyn Monroe," she said, her voice controlled even as the cuffs closed. "I am a United States District Judge. Contact the Marshal's Service directly." He didn't contact anyone. He pressed her forearm higher, tighter, and reached for the file again. Her free hand found the credential reader mounted beside the security door and pressed her thumb against the panel, holding it there 2 seconds longer than a normal scan required. It was a small motion. It was also a duress code, the kind embedded quietly into courthouse security systems for exactly this scenario, and it did what it was built to do. Somewhere above them, a camera specialist watching the East Corridor feed saw an officer with his hand locked around a woman's wrist and toggled the alarm without waiting for confirmation of who she was. The corridor doors sealed. A message reached the Marshal's staging room 4 floors down. Physical contact, credential holder, East Corridor, non-compliant subject refusing to release. 4 deputy U.S. Marshals came through the steel door first. Weapons holstered, movement fast and flat-footed. 6 more followed and fanned out to secure the corridor itself, the file, and the judge, while 2 peeled toward the stairwell to confirm no one else had entered behind him. "Release Judge Monroe," the lead marshal said. "Now." "She had no credential out," the officer said. "She wouldn't stop when I told her to." "The only unauthorized individual in this corridor is you," the marshal said. He didn't let go immediately. His free hand drifted toward his belt, an almost unconscious motion, muscle memory reaching for something familiar in a moment that had stopped making sense to him. A marshal's hand closed over his wrist before it got anywhere near the holster, calm and total, the way you'd stop a door from swinging rather than the way you'd stop a threat. "The file," Evelyn said, once her arm was free and the cuffs were off her instead of him. "Someone needs to check the file." A marshal knelt, examined the sealed clasp. Bent, not broken, the contents intact. Only then did anyone check the officer's name. "Grant Keller," the lead marshal said, reading it off the department ID clipped to his chest, then said it again, slower, once he matched it against something on his own handheld screen. "Grant Keller. Warrant for arrest." Keller stared at the marshal, then at Evelyn, uncomprehending. "For what?" "The marshals were already here to arrest you," Evelyn said, "before any of this happened. You made this part happen entirely on your own." 10 minutes earlier, the corridor had been quiet. Graybridge Police Department had been assigned to exterior perimeter and crowd control for the day's operation, nothing more. The briefing packet Keller had signed that morning stated it plainly. Interior courthouse security. All secured corridors and all execution of federal arrest warrants fell exclusively under the U.S. Marshal's Service. No Graybridge officer had operational authorization inside the building. Keller had initialed that page himself. He left his post anyway. The East employee entrance had been propped for a delivery redirection, held open 2 minutes longer than protocol allowed, while a marshal walked a cart of evidence boxes toward the loading elevator. Keller, still in uniform, slipped through before the door swung shut behind him. The access system logged an unrecognized badge pass. A camera specialist upstairs noted an unfamiliar figure moving off the perimeter map and flagged it, low priority, worth a second look. Judge Evelyn Monroe was walking the same corridor at that moment, for an unremarkable reason. She had reviewed and signed a set of arrest warrants that morning, and was returning the sealed judicial originals to the clerk's secure intake window before the day's calendar began. The certified copies needed for execution had already gone out electronically to the Marshal's Service hours earlier. The file in her arms wasn't operationally necessary for anyone's arrest. It was simply hers to deliver, and she took that obligation seriously enough to walk it there herself, rather than route it through an assistant. Keller saw her first, a woman alone in a restricted corridor, holding something sealed against her chest. "Stop right there," he said. "This corridor's restricted. I need to see that file." Evelyn stopped, credential already coming up in her free hand. "I'm Judge Evelyn Monroe. This is a sealed court file. There's a reader on the wall behind you if you'd like to verify who I am, and the Marshal's Service can confirm my access on request." He barely glanced at the ID. "That's not what I asked. I need the file." "These are sealed court documents outside your authority to inspect," she said. "I'll walk with you to the reader, or you can call your supervisor while we wait for verification. Either is fine." She had offered him every reasonable chance to do this correctly. He threw her credential down instead and reached for the file. Months before any of that, on a cracked asphalt road on the edge of Graybridge, 28-year-old mechanic Darius Bell had been pulled over for a taillight and an expired registration sticker, both legitimate reasons for a stop. He kept both hands on the wheel until he was told to step out. He hadn't raised his voice. He hadn't reached for anything. When he asked, evenly, whether his truck was actually going to be towed for a sticker that was 6 days overdue, one of the two officers on scene knocked his leg out from under him without warning. They moved him behind an abandoned auto parts building 2 blocks off the main road, out of view of the dash cameras and any storefront glass. It wasn't the first time that location had been used that way. A cooperating officer would later confirm it under oath, describing it as a place the unit went when they wanted privacy for something that wasn't going to look right on video. Darius was struck repeatedly while restrained, his wrist fractured, 2 ribs bruised badly enough to require imaging at the hospital that night. The emergency room physician documented the injuries in detail. A displaced fracture of the left wrist consistent with an attempt to shield his face, contusions along both sides of his rib cage, and abrasions on his knees that matched the gravel behind the abandoned lot, rather than anything that could have happened, one on the paved shoulder, where the stop began. He wore a cast for 6 weeks and still, more than a year later, couldn't fully close his left hand around a wrench without a dull ache settling into the joint by the end of a shift. The official report described him as combative and resisting. It became the basis for charges that hung over him for 17 weeks before they were ever reconsidered. During those 17 weeks, he lost 2 mechanic jobs to employers who didn't want the complication of a pending case on an employee's record, however unproven. He stopped driving after dark when he could avoid it, not out of any stated fear, but because his mother noticed he'd started taking longer routes home that kept him on well-lit streets. His body camera footage, when anyone finally looked for it, was marked corrupted. The video file had failed to reconstruct on the server, a corruption consistent, investigators would later determine, with a manual deletion attempt that only partially completed before the device synced. The audio stream, cached separately on the device itself before that sync ever happened, survived intact. The device's internal event log showed something the report never mentioned: a manual deactivation, time-stamped, not a malfunction. On that surviving audio, one voice could be heard, low, almost bored, saying, "Keep it below the shoulders." Officer Eli Dawson found that audio 4 months later, alone in the department's evidence processing room at 11 at night. He was 4 months into the job, still on probationary status. Assigned to routine bodycam uploads because someone had to do it, and he'd come in with a background in network support before joining the department, which made him faster with the software than most of his training officers. He recognized what he was listening to almost immediately. He also recognized the voice. He brought it to his sergeant the next morning. He was told, flatly, to delete it and move on. He didn't delete it. Instead, using the same technical background that had made him useful for uploads in the first place, he created a forensically sound, read-only image of the file, generated a cryptographic hash to prove it hadn't been altered, and wrote down the device identifier, the timestamp, and exactly what his sergeant had told him to do with it. Then he sat on it for 6 weeks. He told himself he needed to be sure. He told himself he had a mortgage and 4 months on the job, and no idea what would happen to either if he was wrong about what he'd heard. What actually kept him quiet, he would admit later, under oath, was fear, plain and ordinary. The kind that doesn't announce itself as cowardice while it's happening. He changed his mind in a hospital parking lot, overhearing Darius Bell's mother on the phone, describing to someone how her son flinched now every time a patrol car passed their house. Eli drove home that night and, instead of storing the file somewhere private, moved it through an encrypted channel to an attorney who specialized in whistleblower matters, preserving the original hash and a written account of everything he'd done since the night he found it. Within 2 days, the material was in front of an assistant United States attorney named Rachel Kim, who ran it straight into an active federal civil rights review of the unit. Rachel didn't build a case against an entire department. She built one against specific people. As an assistant United States attorney assigned to the Civil Rights Division, she moved the material through the federal evidentiary chain the moment Eli's attorney delivered it, logging the original hash, the device identifier, and every hand it had passed through since the night he found it. Independent forensic examiners at an FBI digital evidence lab verified the audio against manufacturer server logs, the device's own event history, and the original upload timestamps, confirming the recording hadn't been altered and that the deactivation log was consistent with what Eli had described. Investigators cross-referenced incident reports across the unit and found language that repeated itself in ways too specific to be coincidence. The same phrases, the same sequence of claims, filed by different officers on different dates. They mapped locations. The abandoned lot behind the auto parts building appeared in more incidents than one. The similarity itself wasn't treated as proof of anything on its own. It was treated as a reason to look closer, and looking closer was what turned 3 isolated complaints into a single pattern investigators could take to a magistrate. The evidence pointed to specific officers. Rachel would say later, not an entire agency, and she meant it as a boundary, not a disclaimer. Judge Evelyn Monroe reviewed the resulting warrant applications the way she reviewed every application that reached her desk, independent of the headlines the case would eventually generate. She read the affidavits. She cross-checked metadata against medical records and duty logs. She examined witness statements against timestamps that didn't leave room for convenient gaps. "I signed because the evidence satisfied probable cause," she said, and that was the whole of her reasoning, stated plainly, with nothing added for effect. Grant Keller's name was on one of those warrants, which was why, when he grabbed for a sealed file in a restricted corridor 2 weeks later and put his hands on the judge who happened to be carrying it, he had no way of knowing he was assaulting the same woman who had already found, independently, that the evidence against him was sufficient to sign his arrest. The moment the marshals confirmed who he was, everything about the case split cleanly into 2 separate tracks, and Evelyn made sure it stayed that way. "I'm a victim in this matter now," she told the chief deputy marshal within the hour, "and a witness. The warrant stands because I signed it before any of this happened, but I can't preside over anything connected to it going forward." She filed her recusal that afternoon. The case was reassigned through the clerk's ordinary rotation to Judge Miriam Cole, who had no prior connection to any of it. "My anger is real," Evelyn told her afterward, the only personal thing she said about the corridor for the rest of the case. "It cannot become legal procedure." At the detention hearing 3 days later, Keller's attorney called the corridor incident a misunderstanding born of confusion and adrenaline. Rachel didn't dispute that adrenaline had been involved. She simply reminded the court that the corridor assault did not create the original probable cause, and that it mattered instead for a narrower, statutory reason. It demonstrated a continued risk to witnesses, to evidence, and to the people still cooperating with an active federal investigation, factors the law required the court to weigh before deciding whether any condition short of detention could manage that risk. Judge Cole found that none could and ordered him held pending trial. The security footage from the corridor itself wasn't made public for several weeks, not until the relevant arrests were complete and the evidence secured. Released then only through the court's own approved channel rather than leaked or rushed. When it did surface, most of the public reaction fixed on the irony of it. An officer handcuffing a federal judge who turned out to be holding his own arrest warrant. Evelyn understood the appeal of that story. She also understood it wasn't the story that mattered. What would have happened, she said, the one time a reporter got close enough to ask her opinion directly? Without cameras, marshals, and a title. That's the version of this I keep thinking about. Not the corridor. The men who don't have a corridor with cameras in it at all. The trial, held months later, was built almost entirely around Darius Bell rather than around what had happened to Evelyn. He testified about the taillight, the sticker, the hands he'd kept on the wheel, and the 2 blocks he was driven behind an abandoned building he'd never had a reason to know about before that night. The recovered audio was played for the jury, authenticated through the forensic chain Eli had preserved from the very first night. Eli testified too, plainly, about finding the file, about being told to delete it, about the 6 weeks he spent saying nothing while he decided what kind of person he was going to be. He didn't dress it up. When Rachel asked him directly why it took so long, he said only that he'd spent that time learning the difference between 2 things that had felt identical until they weren't. Knowing which version of a report to write down and keeping proof safe wasn't the same as using it to protect someone. His department later reviewed the delay itself as a separate matter, a real violation of evidence reporting policy, addressed through administrative review rather than concealed or excused. His cooperation mitigated the consequence. It did not erase it. A cooperating officer, testifying under his own plea agreement, described the abandoned lot, described the phrase, "keep it below the shoulders," as something he'd heard used more than once, and confirmed which supervisors had signed off on reports he knew to be false. He also described the informal understanding that had governed the unit for years before Darius Bell was ever pulled over. Which vehicles were worth stopping, which neighborhoods drew fewer complaints when things went wrong, and which supervisors could be counted on not to ask follow-up questions. None of it had ever been written down. That was, Rachel argued to the jury, precisely the point. Medical records from the night of Darius's arrest were entered without objection. The emergency room physician's notes read into the record, alongside photographs, taken at intake, that showed swelling already visible before he'd even been booked. The defense didn't seriously dispute that the injuries existed. They argued instead that the injuries were consistent with a struggle Darius had allegedly initiated, an argument that held up only until the audio was played and the jury heard, in real time, how calm and procedural the men inflicting those injuries sounded while they did it. Evelyn's own testimony was narrow by design, limited strictly to what she had personally observed in the corridor. Rachel asked only what was necessary. Was she stopped? Did she identify herself? Was verification offered? Was she assaulted? When the defense tried to draw her into characterizing Keller's intent, she declined outright. "I cannot testify to what was in another person's mind," she said, and the line ended that line of questioning entirely. The jury convicted Keller on charges that included deprivation of rights under color of law, falsification of official records, obstruction of a federal investigation, tampering with evidence, and assault within federal jurisdiction. 2 other officers pleaded guilty to lesser-related charges in exchange for truthful testimony, losing their certifications permanently as part of their agreements, a consequence separate from and unaffected by the reduced sentences a judge would later determine. A 4th officer, who had been present at the abandoned lot, but whom the evidence placed there without proof of active participation in the assault itself, was acquitted. Rachel didn't contest the verdict publicly. The process had to mean the same thing, she said afterward, whether it favored the prosecution or not. Darius Bell's original charges were dismissed and formally expunged from his record. He received a civil settlement covering medical costs, lost wages, and the legal fees he'd spent fighting an accusation that should never have existed. Nothing in the settlement pretended to undo the injuries that still ached in cold weather, or the flinch his mother had described on the phone that night. He began, on his own terms and without obligation, helping other people in Graybridge file complaints they'd previously assumed would go nowhere. Eli left patrol work within the year and moved into the department's newly created body camera oversight unit, a decision that made sense given both his background and his history with the case, though no one treated it as a reward that balanced out the 6 weeks he'd stayed silent. The reforms that followed were grouped deliberately into 4 categories rather than left as a long, undifferentiated list. The first addressed evidence integrity. All body camera footage now moved automatically to immutable, off-site storage outside any single department's control, with legal holds triggered the moment a serious complaint was filed and independent audit trails attached to every file. The second addressed external review. Manual deactivation of a camera during any use of force incident now triggered an automatic alert and required a documented reason, with legitimate exceptions still permitted for matters like victim privacy or a confidential source. But every deactivation logged and reviewed by someone outside the officer's own chain of command within 24 hours. The third addressed reporting protection. A confidential hotline and legal assistance channel, independent of any department, was established for officers who discovered misconduct, with explicit anti-retaliation protections extended specifically to probationary employees, like Eli had been. The fourth addressed pattern detection. A system now flags incident reports across a department that share identical or near-identical language, not as automatic proof of wrongdoing, but as a signal for human review before anything is closed. The same system now cross-references those flags against incident locations, so that a cluster of reports tied to the same stretch of road, or the same stretch behind the same abandoned building, surfaces on its own, instead of waiting for someone like Eli to notice by accident 4 months into the job. Graybridge Courthouse security changed as well. Officers assigned to exterior duty now sign a specific operational boundary acknowledgement. Secure interior doors require credential verification with a documented exception process for genuine emergencies, and a marshal is posted permanently at every employee entrance, rather than relying on delivery staff to manage access. The reforms didn't claim to fix a department on their own. They simply removed several of the quiet gaps that had allowed one unit to operate the way it had for as long as it did. When a board member later proposed a plaque commemorating the corridor incident, Evelyn declined without hesitation. "No plaque," she said. "I need a verification process that works the same way for everyone." 6 months after the trial ended, Evelyn walked that same corridor again on an ordinary morning. Ahead of her, a member of the overnight cleaning staff approached the same secure door, presented an ID Evelyn had never seen before, and waited while it was scanned. It took under a minute. No one asked him to explain himself twice. No one treated the pause as suspicion. The reader beeped, his badge was handed back, and he went on to finish his shift. Evelyn watched him pass through and thought, not of the marble wall, or the 12 marshals, or her own name on a warrant she hadn't known would matter, but of Darius Bell, who had never been given even that much verification before the force started. Justice wasn't measured by how well the system had protected a federal judge. It was measured by whether it protected someone like Darius Bell, someone with no camera crew, no marshals, and no title large enough to make anyone stop and check. Should manually disabling a body camera during a use of force incident automatically trigger an outside investigation? Leave your answer below.